Hi, everyone. Good morning or good afternoon, depending on where you are. We are so excited to have you here today to join us for what we hope is a practical and useful discussion about a very timely topic. But before we get into introductions, I have a couple of pointers about the platform that we're using. So on your screen, you should see a few icons. One of them is the resources icon that will include a copy of this presentation. Please feel free to download it and follow along with your printout if you'd like, or save it afterwards, whatever you want to do with it. Second, you should also see a Q&A feature, and you can use this to submit any questions that you have throughout the program. Only Brian and I can see your questions. They won't populate as a group chat, and we'll work to address them at the end. Given our limited time together, and we want to respect the time frame that we have and your next commitments, we might not be able to get to all of the questions. We will save them and follow up with folks in writing if we don't get a chance to get to your question. And you can also always feel free to email either one of us about this afterwards or anytime. We really, truly love talking to folks about this topic and would be happy to think through anything with you at any time. Please also note that the presentation is being recorded. It's my understanding that we'll circulate a link to the recording together with another copy of the webinar deck after the presentation is over. I think that that's set to go out tomorrow. So please feel free to use that for yourself or share it with others on your team. So just a little bit about our firm before we get started. I see that we have many friends and clients of the firm on the call, but for those of you who haven't had a chance to work with us, I think we are a pretty unique large law firm. We have over 1,100 lawyers in 21 locations, but I think what makes us a little bit unique for a law firm of our size is we really have an incredible labor and employment practice and a terrific education industry team. So I think we have the resources of a large law firm and the global reach of a large law firm, but with fairly unique practice areas that you'll hear a little bit more about today when we talk about these topics. Before we jump into the agenda, I want to take a moment to introduce you to my wonderful colleague, Brian Barger. So Brian's a partner at our firm in the Labor and Employment Group in our Charlotte office. And when I tell you that he has been my go-to person on this topic for the last 16 years, that is not an exaggeration. His practice really focuses on affirmative action in the employment context, including defending clients in affirmative action, systemic discrimination enforcement litigation, compliance audits and compliant investigations and complaint investigations brought throughout the country by the Department of Labor and the OFCCP, which hopefully none of you have ever had to deal with. And he regularly works on preparing and updating affirmative action plans and programs and counseling clients regarding compensation analysis, hiring and promotion systems, and federal record-keeping requirements. He's also worked with national and international clients on database issues, applicant tracking and selection systems, and their design and reporting. So really all things that touch affirmative action in the employment context. Brian is just really a terrific wealth of resources, and he's also, most importantly, a really nice person and fun to work with. I'm Sarah Wake. I'm a partner in the Labor and Employment Group in our Chicago office. I started my career here in the Labor and Employment Group right when I graduated law school and left about 10 years ago to spend nine years in higher education. While I was in higher education, I most recently spent 5 years in-house at a Division I private research institution where I focused on all issues related to students, including student litigation, discipline, privacy, and applicable today, student admissions, both in the undergraduate and graduate context. I also worked on issues related to diversity, equity, inclusion, and athletics. And prior to that, I was at two great institutions where I was not in their legal office, but rather I ran the business unit responsible for equity-related responses and initiatives for students, faculty, and staff, including serving as the Title IX coordinator, the 504 ADA coordinator, and relevant to today's conversation, the affirmative action officer for those institutions. So this icon here on your screen really kind of begs the question that I think people are asking in the wake of the Supreme Court's oral arguments on affirmative action in the context of undergraduate admissions, which is the sky falling? And I think that, like with most things, the truth lies somewhere in the middle of the Acme anvil and the acorn. There are certainly things that we need to think about. There are there are steps that we should be taking now, both in the university and in the employment context. And what Brian and I are hoping to do today is really just give you a practical nuts and bolts kind of framework of both of these areas of the law and what we think you should be doing in preparation for a potential ruling from the Supreme Court that could impact the limited use of race and relation in undergraduate admissions, but also just what you should be doing in general in both of these spaces. When Brian and I were discussing this topic, it really stood out to us that this term affirmative action is used in both the undergraduate admissions and the employment context. That same phrase is used, and it means two completely different things. And I think that becomes complicated when there's not a coherent understanding of what the term means in each space. And I think it becomes further complicated when you overlay diversity, equity, and inclusion initiatives on top of this affirmative action space. So what we want to do today with the goal of giving you some real practical takeaways is first talk about the Supreme Court cases that were heard, before the court on Halloween, ironically. And after we talk to you about the Supreme Court case, we're not going to spend a lot of time talking about, here's what Justice X said or Justice Y did, or here's how we think that they might come out. This is not the purpose of this webinar. We're really going to then dive into affirmative action law generally, both in the education and employment contexts. We'll talk a bit about the oral arguments and potential impacts of the ruling in both of these spaces. And then we'll give you some, pretty practical, we think, takeaways of what you should be doing in the months ahead. So I'm going to turn it over to Brian, who can give you an overview of the Supreme Court cases.
Thank you, Sarah, and good afternoon, everybody. Nice to see you. Thanks for joining. Like Sarah said, I think before we dive into the oral argument and some of the interesting takeaways that we glean from all of that, I think it's helpful to start first with just a basic understanding at a very high level of the background for the two cases that are actually before the Supreme Court. And I think the first thing I would note, and this is really important, you'll see this later in other slides, there are two cases, and they are in many ways somewhat different. There's one case against the University of North Carolina, Chapel Hill, right up the road from here, and a second case against Harvard. Review was initially granted by the Supreme Court back in January, as Sarah said. It's oral argument on Halloween. Ironically, this year I did not see a Justice Roberts costume come through my house, but who knew? I looked, but there was none. But they ironically did oral argument on Halloween. But it's going to take a while for a final decision to come down. We expected something probably in the spring, but maybe, frankly, in the summer of 2023. So we have time to digest it a little bit and to make some plans, which is why we're doing this webinar here today. But even though they're two separate cases, interestingly enough, they have the same plaintiffs, Students for Fair Admissions. And likewise, they have basically the same general claim with some nuances. And essentially, the claim is that both schools' race-conscious admission practices unlawfully discriminate against Asian American student applicants and are therefore unlawful. That's the essential claim. So how do they base those assertions? Well, they attack it in a couple of different ways when you read the briefs. First is a sort of more of a straightforward statistical analysis that Asian American students are significantly less likely to be admitted than similarly qualified white, Black, and Hispanic students. And a lot of the briefs, a lot of the oral argument actually focuses on just what that evidence shows, whether the statistics are in fact significant statistically or legally. And that's similar to things that you'll see, frankly, in the employment setting. And a good bit of the case involves that. But if you dig into it a little bit more, part of the case also effectively deals with the consideration of race as a plus factor, which is unique in the education setting, and whether that it really passes constitutional and statutory muster anymore. So what SFFA sort of essentially argues, number one, is that the use of race as a plus factor essentially acts as an Asian penalty, and that's their words. And so that argument really is an argument that it's either discriminatory in practice or in effect. But related to that, if they're pointing to what exactly does that violate, there are actually two items they point to. The first is Title VI of the Civil Rights Act of 1964. And I know this is certainly a constitutional issue at its heart, but interestingly enough, when you think about Title VI, which applies to private and public entities that receive federal funding, Title VI is actually sort of a straightforward statute. It says, no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So the language, the key language is on the grounds of race, color, national origin. Of course, the Grutter test, which Sarah's going to talk about in a little bit more in a moment, does on its face take into account race. And so one of the questions that the plaintiffs in the case asserted is, hey, you read this express language in Title VI, on its face, it says you can't do this. Why do you allow this under Grutter? So that's attack number one. Attack number two is an argument about the 14th Amendment of the Constitution, which provides equal protection under the laws to public entities. So for schools like UNC Chapel Hill, the 14th Amendment would apply. And so it's really sort of a dual attack, which is also why the court took up two different cases, one against a private entity and one against the public. The other assertion basically that SFA is arguing is that basically the Grutter decision should either be overruled on its face as unconstitutional or simply ended or sunset. And Sarah's going to talk about this in a moment. But the interesting thing about Grutter in part is that it was always designed to have sort of a tailing edge, and that it would be essentially sort of come to pass over time that would no longer be needed, and that the court might, in fact, strike it down at a later point. So part of the debate is, are we at that later point? The other interesting thing about Grutter, and we'll talk about this towards the end, about options, about what we think is going to come out of these cases, even if Grutter is not overruled, there is a secondary argument, sort of a second line of attack from the plaintiffs in the cases, basically on two fronts. Number one, that even if Grutter stands as applied, in theory, it sounds good, but in practice, it's not workable, and that the court should take another look at that test and maybe tweak it. That's option number 2A. Option number sort of 2B that the plaintiffs argue is that, well, even if Grutter is upheld, and even if you keep the framework as is, no changes, they argue that Harvard and Chapel Hill basically failed that test. In part, they argue that race was allegedly not being really used as a plus factor, but it really was the factor, and that therefore the schools sort of engaged in alleged racial balancing, which is illegal under even Grutter. And then a secondary argument is that, well, hey, they claimed there were sufficient race-neutral alternatives that were available that the schools either didn't appropriately look at or should have looked at, and therefore it fails under the Grutter test as well. So there's a number of different arguments, some of which are statutory, some of which are constitutional, and some of which are really related to the Grutter test itself. And so I guess with that, I'm going to turn it back over to Sarah to talk about the test, and then I'll talk some more about the employment side of that.
So let's talk about the kind of current state of affairs when it comes to affirmative action law in higher education. So the general framework is that educational entities are generally not allowed to use race as a factor. In K through 12 student admissions, generally there are some exceptions to that. In faculty or staff hiring, in housing, or as a plus factor or otherwise in such circumstances. Brian and I will dive in later to this idea of faculty and staff hiring and how that fits into the larger framework of employment law in general, where you are not supposed to consider any protected class when making an employment-related decision. And that certainly applies to faculty and staff hiring at colleges and universities, which I think is now becoming a little bit complicated as many universities and other employers launch or further diversity, equity, and inclusion initiatives designed towards enhancing representation on your campuses or within your employer spaces. And this is true generally in higher education, this prohibition on using race as a factor, even when the intent is advancing racial or other forms of diversity on your campuses. So that's the framework from which we start. based, on the laws that Brian just spoke about. And the Grutter case and other cases, both before and after it, really established the current framework that we're in. And under the Grutter case primarily, what the court said is that it's okay in some limited circumstances to consider race in the admissions process. The Grutter case was a law school case. There have been others that talk about undergraduate admissions. But what the court said is, in order for you to be able to consider race in the admissions process, you have to satisfy the strict scrutiny standard. It's interesting to me as a former Title IX coordinator that this is not the standard related to sex. So it's a little bit easier to consider sex in these decision-making processes than it is to consider race. And one of the main reasons for that is because Title IX has a specific regulation that speaks to the consideration of sex. And I'll circle back to this at the end when I talk about how you might want to be thinking about the impact of these decisions on things like donations that you receive or scholarships that your institution is using that are designed to reach certain racial or ethnic group or someone on the basis of sex. So said another way, the strict scrutiny standard as applied to affirmative action in undergraduate admissions means that colleges and universities can consider race as part of their admissions process if it's narrowly tailored to meet a compelling interest. And the court has said that a university's interest in assembling a diverse student body is a compelling interest. I think one of the questions that the court was diving into with the Harvard and UNC Chapel Hill cases is it still a compelling interest for universities to have a diverse student body? The reason that line of questioning about is this still a compelling interest is interesting to me is because in the Grutter case, Justice O'Connor's opinion really kind of flatly said, we are giving great deference to colleges and universities in terms of their ability and desire to craft a diverse student body. And that was pretty absolute in that opinion. They focused more on how it was narrowly tailored, how what the University of Michigan was doing was narrowly tailored, but it was pretty well supported in the opinion from prior precedents that we are going to give deference to colleges and universities that say that they want to construct a diverse student body. So I found that to be interesting. And at the end of the day, what Grutter and Fisher and some of these other cases that we think about in the affirmative action space in the context of undergraduate admissions and graduate admissions means is that admissions officers and teams need to engage in an individual student admissions assessment. You can use race as a plus factor among many other factors, and race itself cannot be determinative. And you need to kind of, at some regular cadence, evaluate the use of race-neutral admissions practices to see if those race-neutral admissions practices allow the school to maintain their desired educational objectives. In this case, do those race-neutral alternatives allow you to maintain a diverse student body? And I think this is really so important that I made a separate slide about this, because I think there's a lot of people who just think you can use race willy-nilly. That's the legal term, willy-nilly, in the admissions process, and that's just not the case. And in my experience working with clients, there are many institutions right now who probably wouldn't meet that narrowly tailored analysis that the lower courts in the Harvard and UNC cases were so keen on undertaking. And I'll talk about that in a moment. But the Grutter framework prohibits making admission selections based solely on race. It prohibits quotas, and it also prohibits racial balancing. I think that Grutter, as applied in the SFFA cases, it's important to think about this in the context of what the lower courts did, particularly in the Harvard case. They did it too in the UNC case, but I spent, frankly, much more time kind of listening to the testimony and reading the transcripts in the Harvard case. And the lower court said, look, there's no evidence that anybody involved in the admissions process was intentionally discriminating or engaging in racial balancing. It wasn't as if They were projecting up on a screen, we need 30% of our class to be of X demographic. How are we lining up against that so far? And the court's kind of key observation with Harvard's admissions practices was that race was really used in a flexible and non-mechanical way. Similarly, in the UNC Chapel Hill case, I think there was something like 40 different factors in 8 or so different categories that those admissions folks looked at so closely with each candidate to kind of see how does the candidate line up. And that kind of wide range of factors and that intentional evaluation of all these factors is really, in my opinion, what allowed the lower courts to say what you're doing is narrowly tailored and therefore passes the kind of the constitutional or statutory scrutiny at issue here. There was the court also found in the Harvard case that there was no significant or clear statistical evidence of bias against Asian American applicants. And the court noted, look, they considered race neutral alternatives. They considered if weighing for low socioeconomic status would have the same impact. And what the court concluded, and I think what Harvard concluded, was that using socioeconomic status would reduce racial diversity and also lower the average entrance scores, which the court found to be non-desirable outcomes. So I think this kind of intentional periodic evaluation of whether there are workable race-neutral alternatives and the wide range of factors that were considered with each applicant were kind of the key components in both the Harvard and the UNC cases. As Brian mentioned before, some of the justices in the SFFA cases spent some time talking about the sunset that's mentioned in Grutter. It is true that near the end of Justice O'Connor's opinion in Grutter, she very clearly says, look, this is dangerous. The use of race, even in this narrowly tailored way, is a dangerous practice, and it's not what the Constitution was designed to do. And so there was very clearly an idea in the court's opinion that there would be some guardrails around the limited use of race in admissions, even under the strict scrutiny standard. And the quotes from that case are there, but the one that some of the justices were really pushing on was the line in the Grutter case where Justice O'Connor said, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest of proof today. So for those of you that listened to the 5 hours, you saw that some of the justices were really pushing on this 25-year time frame, which is about up. It's been about 25 years since the Grutter case was decided, and they were pushing on this question of, do we still need to do this? So with that, the kind of overarching framework in the educational context, I'll turn it back to Brian to talk about affirmative action in the employment context, which means something vastly different than in the undergraduate or graduate admissions process.
Thanks, Sarah. Yeah, as Sarah mentioned just a moment ago, again, what makes this hard is that even though you read the cases and you hear the articles and the press coverage in the education context and sometimes in the employment context, you'll hear similar phrases about affirmative action and diversity initiatives and pipeline development and all these other kind of phraseologies that are sprinkled throughout these cases. And yet, in many circumstances, some of those terms have entirely different meanings. And part of that is because they're based on entirely different statute. And that's definitely the case in the employment setting. Unlike education, as most of you know, in the employment setting, most private and public employers, which includes universities and colleges, like Harvard, like Chapel Hill, are covered by Title VII of the Civil Rights Act in 1964. That's the base non-discrimination statute, which includes race and gender for any employer with 15 or more employees. But there are other federal non-discrimination statutes as well, the ADA, the ADEA, the Family Medical Leave Act, and there are a plethora of state and local non-discrimination laws. That law is out there, separate and apart from anything you see in the education setting. Separate from that, there are certain covered federal contractors and subcontractors are covered by 3 different rules: Executive Order 11246, the Rehab Act in 1974, and the Vietnam-era Veterans Readjustment Assistance Act. Executive Order 11246 deals with affirmative action for minorities and women. The Rehab Act deals with disabilities. It's actually the act that was the precursor to the ADA that applied to federal contractors and subcontractors. And VEBRA applies to covered military individuals. So it has a different construct, but within that, different employers take different approaches depending on how they're covered. So even if you're not a covered federal contractor or subcontractor, you're already covered by Title VII. You're already covered by these other rules, but you may decide on your own to engage in voluntary employee DE&I efforts. And that's common across the United States with many employers. Separate from that, either because they're not a covered contractor, or if they are a covered contractor, they want to do it on top of what they're already doing with DE&I. If you're covered by Executive Order 11246, the other rules, and you're triggered to sort of cover and do affirmative action, you have to engage in a particular flavor of affirmative action that's statutorily required. And among other things, you're required to engage in, quote, affirmative actions for minorities, women, disabled, and certain protected veterans. You're required to develop and maintain a very detailed written affirmative action plan, which has about a half an inch of a narrative every year and 3 inches of regulations that go, and statistics that go behind it, where you do basically a statistical self-analysis based on certain regulatory prescripts that are different than your maybe voluntary DE&I efforts. But the general concept, at least from a regulatory standpoint, is it's more than non-discrimination. Non-discrimination, when I do training on this, I tell people non-discrimination is thou shalt not. Thou shalt not do bad things based on race, gender, national origin, disability, etc. Thou shalt not retaliate. Thou shalt not engage in harassment. These are sort of prescriptive items. But affirmative action is supposed to be more. It's the positive side of this. In addition to non-discriminating, which everybody has to do anyway, you're required to take extra efforts for outreach and postings and notices and training and compensation analyses and a plethora of other sort of rules and regulations that attach to that are specifically aligned under Executive Order 11246 and the other regulations. And so for different colleges and universities, some of you may be only under one box. You may only be under Title VII. You may not be covered by Executive Order 11246 and other federal contractor rules. Others may not. They may be covered by both. And the same thing applies to employers in the non-education setting. Both voluntarily required affirmative action in the employment setting and sort of the regulatory required affirmative action basically seeks the advancement of diversity through a couple of different ways, basically through targeted outreach, where you're not just sort of casting seeds wildly as part of recruitment, but you're thinking long and hard about where you're going to meet and reach a diverse workforce as part of the applicant flow that you seek. It requires some self-reflection about your policies and procedures and whether there are any kind of artificial barriers, both to entry and advancement. They both voluntary and regulatorily, individuals typically establish goals versus, again, rigid quotas that you use to sort of set sort of aspirational efforts to sort of reach sort of movement towards diversity. And they require you to sort of, again, under the voluntary side and non-voluntary side, to do some self-analysis to see how we do it on those goals. And yet, the hard part about this, and I think this is where people sort of jump the track sometimes, I think, especially when they think about the differences in education versus employment. Unlike the education setting, the law remains for voluntary DE&I and for regulatory affirmative action. You cannot discriminate on the basis of race, either under this disparate impact theory, about both of those theories. Disparate treatment is basically the intentional use of race or gender as a positive or a negative factor in employment action, pro or con. And so unlike education, where race can be among many factors as part of selection consideration when you're looking at student admissions, that is not the case in employment. Race, in fact, cannot be any factor whatsoever in employment selection. Likewise, there's a disparate impact theory where even if you're doing facially neutral practices, that aren't designed to discriminate. You haven't backed into a discriminatory issue. You can, in fact, create policies and practices that sometimes have an unintentionally adverse impact on individuals, and that too can give rise to a discriminatory claim. In both theories, disparate impact, disparate treatment, run both directions, both for and against the majority and the minority. And so it's a very different kind of legal construct. Now, some of you may be saying, wait a minute, I've heard there's an exception to that, that in some circumstances, depending on the history of an individual organization, you might be able to engage in limited racial preferences, even in the employment setting. And that's true. That is true. There is a case, Johnson versus Transportation Agency, that's out there, that's been around for a while. But boy, I will tell you, it is a very, very limited exception. It only talks about the use of race-based preferences if you can show really three things: that there was a manifest imbalance in traditionally segregated job categories within your organization, and you can show that through statistical history and analysis about your practices, both then and now. What you do as far as a race-based preference is temporary, and it can, quote, not unnecessarily trammel the rights of non-preferred individuals or act as, quote, an absolute bar to advancement. And sort of like in the other settings, you can't have set-asides, quotas, or ceilings engaged in that practice. The problem with this, of course, is here in 2022 versus in the 1960s, hitting this target can be sort of a hard nut to crack. And when you do it, just frankly, the documentation that you create to show this manifest imbalance, both historically and in the present real time, is basically creating Exhibit A for everybody to sue you about the imbalance that you just created. And so most employers are pretty nervous about that here and now in 2022, and do not attempt to sort of justify their voluntary affirmative action or regulatory affirmative action programs based on the Johnson test. There are a few exceptions that are still out there that I know of, but boy, they are rare. And so even though this exists as a practical matter in this day and age, most people do not meet this test and don't try for that matter. The other thing I would say, again, from an affirmative action standpoint in employment, like I said, race cannot be a factor in an employment setting, pro or con, as on its own or as part of a group of selection factors, even if it's not the determinative factor. That's very different than the Grutter test. But again, in employment, it cannot be any factor. And the concept of diversity itself, even though it's super important, does not have the weight that you see in Grutter. Diversity itself, even though super beneficial from an employment standpoint, social standpoint, it is not sufficient from a Title VII rule or under Federal Executive Order 11246 affirmative action. It's not sufficient to justify engaging in race-conscious selections. That's just not the test. A lot of people think it should be the test, and good people can debate about that and whether the laws need to change. But here we sit in 2022, and that's just not where we are as a legal standpoint. So, Sarah, with that in mind, let's talk about the oral arguments a bit. I mean, I think a lot of people are interested in our take on that. We've gotten lots of calls. I know you've been interviewed a couple times for the papers and in the press about this. What jumped out to you from your perspective on the education side?
Yeah, I think we have here what the kind of the battle lines were, right? So I think the main battle line, which is, how the two sides were thinking about the issue is, there was clearly a camp of people that were indicating by their questions that Grutter was wrongly decided to begin with, or isn't a workable standard, or that it's just not working, that we've had enough time to try to get Grutter up and running and to have it work in measurable ways, and it's just not working. And then there was clearly a camp of justices who were asking questions that suggested that they think, look, we think the limited consider of race in admissions is still necessary to achieve diverse student bodies. We're not there yet, in other words. We wish we were there, but we're not. And I think the kind of underpinning of all of that was the key question of, is racial diversity still a compelling interest in 2022? And I think that we saw some of the justices asking questions that were making points that really illustrated, the nuances of this, that it's not so simple as just saying we don't still need to consider this a compelling interest in 2022. We're this very progressive world now where we don't need to do that anymore. I think considering some of the things that happen in the world around us, some of the justices were right to kind of push on this issue and ask, are we really in a place where we don't need to consider the value of constructing a diverse student body anymore? I think that the secondary line of questioning that people were focused on was, okay, let's say that some type of test from Grutter can still exist. Is what we're doing now the right thing to do? So how is this really working in practice, and how should it be working? Is there a better way to do this? And some of the justices focused on questions about checking the box. Essentially, the questions were, well, if you're not really considering race as a determinative factor, why do applicants have to check the box on what their race and or ethnicity are? And I think, justices were also asking the question of how do you show what the value of student diversity is, and how do we know when we've reached enough diversity to meet an institution's educational goals? So in the Grutter case, the court talked a lot about a critical mass of underrepresented students and the value of having a critical mass of underrepresented students in the classroom, and how that could show that there was not, this kind of minority viewpoint is the language that they used assigned to a particular class of students, but that viewpoints come from all different types of students from all different types of places, and that the kind of engine of debate and our ability to engage in free and rigorous inquiry is enhanced by the presence of diverse voices. And so I think that the court pushed a little bit on how do we know when enough is enough? When will you have met your goals? And I found it interesting that it didn't feel to me like the schools could really answer that question. It felt a bit pie in the sky to me. They couldn't really pinpoint when they will have met their goals. They just were saying things like, well, we're not there yet, but we hope to get there soon. But they couldn't really say, this is what it would look like when we get there. And I think that could possibly be problematic from the lens of some of the justices. And then I think we saw particularly Justice Barrett asking, she was the one who started to ask the questions about, well, what about this sunset? What about the language in Grutter that says that we're not supposed to do this forever? When is enough going to be enough? And people asked me prior to the oral arguments, which justice are you the most interested in watching? And I said, I'm the most interested in watching Justice Barrett, number one, because we don't have really any indication on how she might vote related to affirmative action. People had suspicions based on, ideological alignment, but they didn't really know for sure. And the second thing that was really interesting to me about her is that she, unlike any other justice on the court, she was a faculty member for a very long time. She was pulled from the faculty at her institution to sit on the Seventh Circuit Court of Appeals. And so I think she has a unique perspective about this idea of how diversity in the classroom works. So I was interested in her line of questioning, and I think it played out that way, that she really asked a line of questions that suggested that there might be some middle ground here. So that's what was interesting to me. And Brian and I were kind of dorky. We listened to it together. I'm kind of like nerding out about the oral argument for all 5 hours. And I was kind of looking at it from the higher education lens, and he was looking at it from the employment lens. So Brian, to you, what was interesting to you in the employment context about the oral arguments?
Yeah, thank you. Unfortunately, they don't televise these things, so you can't wait for the movie. You got to actually listen to it or read the transcripts. But yeah, I was listening to it with an ear towards, okay, what are the things that jumped out to me about the questioning, in particular, of some of the justices that might lead me to think that even though this is an education case, they may put dicta or other sort of stray language in the decision that has some trickle-down effects into employment and, frankly, even beyond employment. And there were a couple things that, Sarah and I talked about earlier that jumped out. I mean, the interesting thing to me right out of the box was there was a lot of debate early on about just what's the definition of diversity. Several of the justices asked point blank all the presenters about how they would define that and how they use and define underrepresented. And likewise, whether the classifications used themselves, things like Asian and Black and White and Hispanic, are themselves workable. I thought that was really interesting because, in part, that's a debate that we're seeing in corporate America about how people sort of do their own, especially voluntary DE&I efforts. How you define that within your own organization is often a challenge. But I thought it was really interesting. Justice Alito, in particular, he took this argument head on. He said, I like your response to the argument that these racial categories are so broad that any use of them is arbitrary and therefore unconstitutional. Now, boy, to the extent that they jump to that argument in a later decision, that would be really interesting and could have a lot of different effects. But he goes on, he says, so what would you say, for example, to a student whose family came from Afghanistan and doesn't get in because the student doesn't get the plus factor that the student would get if the student's family had come from someplace else? So you would say to that student, well, we don't need you to contribute to a diversity of views in our school because we already have enough Asians. We have a lot of students whose family come from China or from other Asian countries. And the student says, well, you don't have anybody like me. I'm from Afghanistan. That's an interesting argument, and it's a struggle. Even the EEOC and the OFCCP is struggling with this and thinking about whether to change some of the categories that are tracked as part of regulatory affirmative action. And so I think sort of what the court says here, I think is going to be really interesting. There's a lot of discussion, too, about an issue we do a lot of training on. I know Sarah does a lot of training on this, about sort of when and how should you report up metrics within an organization, whether that's education or non-education. The whole issue of sort of real-time diversity metrics and who sees it and when they see it is interesting from a risk standpoint, because arguably if you're flashing up numbers on a regular basis to people who are actually making decisions about selection, whether that's admissions or employment, the risk is that somebody can always come back and say, well, the only reason you're looking at that is because you're taking that into account, and you're not allowed, especially under the employment side, to do that. You're not allowed to take into racial considerations. There are limits on that are different on the employment side, but there was a lot of debate about the timing and who sees what when that I thought was definitely interesting. And likewise, I think the other thing that I thought really jumped out to me, and this was from Justice Kavanaugh, and he had a discussion, Sarah, about race-neutral policies. And this is part of the Grutter test, but this is also part of DE&I and regular sort of regulatory affirmative action, when and how you can adopt race-neutral policies if the overall intent is to achieve a certain racial balance. I'll just read you one quote. He said, so let's say you prevail here. Let's say as a university you develop 3 race-neutral alternatives to consider in the wake of a decision here, and they choose the one that's going to lead to the highest number of African-American students, and they choose that race-neutral alternative for that reason. Is that okay? And then there was some discussion about that, but he circled on, about 10, 15 minutes later, he came back to the same issue and said, well, look, your position will put a lot of pressure going forward if it's accepted on what qualifies as a race neutral in the first place. And I think he's right. I mean, that's a really interesting question. What is a true racial neutral policy or gender neutral policy? Can you back into certain policies with the goal to achieve certain efforts? And by that backing in, is it intrinsically race-based and therefore illegal under Title VII, illegal under Executive Order 11246? To the extent they riff on that in a decision, boy, I think that can have a lot of different effects. Anything else jump out to you on that, Sarah?
Yeah, I mean, for me, the point that you're making about are you using something as a proxy for race is an important one. I think particularly in the admissions context for colleges and universities, if a college and university's solution to not being able to use race in a limited way is we're going to pivot and look at geographical areas. By way of example, the town that I'm from is 99% African American. So what if a school says, we are only going to now recruit, or we're going to more heavily recruit from Sarah Wake's hometown? by virtue of doing that, our numbers of African American students remained steady, or it increased from the time prior to the SFFA cases being decided. I think that it would be very plausible to say, look, that was just an impermissible proxy for race, and you can't do that. You're doing the same thing that you were doing prior to these decisions, and that's problematic. And so I think that's why, if I was still in-house at a university, that's why this would be so stressful to me, because I wouldn't quite understand. And this is the value of precedent, of course, right? Right now, colleges and universities know what they're supposed to do. I think if Grutter is overturned, people really aren't going to know how to do this, and they're going to try to figure out the best thing that they can, but it's going to be a very uncertain and stressful time for these institutions, because I think it's likely that everything that they do will be scrutinized.
Yeah, that's an interesting point, too. And the whole idea of that pipeline development, there's always been a lot of case law, especially in employment, about selection, right? But courts have always given a certain amount of deference and leeway to the idea that it's okay to recruit a big bucket, even if you're targeting certain sectors to fill that bucket, because you're just trying to get people in, but you're not putting your thumb on selection. If, in fact, this court goes further and says, I don't know about that, we have concerns about the targeting itself, going back to your example with your hometown, boy, I think that can have a lot of interesting effects on all sorts of sort of practices that are pretty common across the country. So, yeah, that's a huge issue. Well, let's move on to a couple other things. We want to be respectful of your time. So if you're thinking about what's the likely impact, what's going to happen, here's a slide about sort of some of the alternatives that may come down. There's a possibility, frankly, that the case can get tossed on standing, just on its head. I doubt that's the case because they took it up and they really thought that strenuously, and they had enough votes for that they wouldn't be arguing it. But there is that argument that's out there. They can certainly rule for or against Chapel Hill or Harvard based on Grutter, and rule for one versus the other. They can overrule Grutter itself. They can end Grutter based off of not overruling it, but as to the sunset that Sarah talked about. Or the more interesting thing, I think, is they might come up with a mixed approach. Keep in mind, like we said at the beginning, these are two different cases. They can have different outcomes, and they're also based on different statutory and constitutional principles. And so some courts can take a very strict view. Some justices can take a strict view of Title VI, for example, but still feel there's leeway under equal protection, and they can have different outcomes based on that. And so ultimately where the courts lands on this, it's hard to say, but our guess is either they're going to take a hard swing at Grutter overall, or they're going to come up with a mixed adoption. I think what Sarah said about Justice Barrett and others, and some of the commentary that they made about timing, makes you wonder about whether an option 6 will come up. But we'll have to see. There's also some interesting dialogue about military academies, and for other constitutional reasons we won't get into, there could be a potential carve-out given the executive branch deference that is given towards defense considerations. And so, again, if you're thinking about what else is in the mix, depending on who you are, who knows? They may carve out something ultra special just for military academies. But on the higher education side, Sarah, what do you think, and what do you think is going to happen coming out of this?
Yeah, so here's where we pivot to the part that you probably care about the most, which is practical advice. So for my friends from colleges and universities who are thinking about what to do in the undergraduate and graduate admission space, so if they overturn Grutter immediately, you're going to have to stop using race as part of a holistic review, and you're going to have to redefine how you're thinking about constructing your incoming classes. This I just touched on is very complicated because you're going to need to think carefully about where else you're looking for your students and what your stated goals are. I would recommend if Grutter is overturned, obviously those of you in legal offices will need to jump on that and do some training right away with admissions teams. I think you're going to want to audit your internal and your external facing documents to make sure that there's nothing in there that could suggest that you are using race in the admissions process. And I think you need to be prepared to look at the data. So when your admissions processes change, if they have to, really look at what's happening to your numbers after you stop using race in admissions, and how are your race neutral alternatives playing out. to the point that I just talked about before. If you pivot to a geographical model, if you pivot to a socioeconomic model, what's the actual impact on your data? If there's a sunset, what I would call kind of the Justice Barrett approach, and it's not overturned immediately, but we're given some more finite of a deadline, you're going to need to do the same over time. And if the Grutter framework continues, it either continues indefinitely or continues with some end date in mind, I think it's really important not to kind of rest on that. Remember that the analysis by the lower courts was incredibly nuanced. The court was not saying it's okay to claim that you can use race as a plus factor or engage in the holistic admissions process and just call it a day. The details really matter. And from my experience working with colleges and universities, admissions offices are very siloed. There are not a lot of people at the institution who know what goes into the special sauce. And if I were in a legal office at an institution right now, I would be knocking on my admission officer's door and I would be saying, sit down with me and talk me through this. Show me your documents. Talk to me about what you tell your committee. Tell me how you make these decisions. What kind of evaluation forms do you use? And let's be on the same team here to kind of think about that. And I would say the things that I have starred under the first category of if Grutter is overturned immediately, I have those starred because I think you should be doing those things now. I think you should be doing training, looking at your documents, internal and external, looking at your data. And for those of you who are the business unit leaders who do admissions work, for those of you who are the legal office point of contact that advises on admissions, I would really be digging into the details now and figuring out what my process looks like.
Super. Thanks, Sarah. So on the employment side, we've been getting a lot of these questions. What if Grutter is overturned? What do we think about this case? What's going to be the impact of it? And unless, going back to one of my earlier statements from one of the line of questioning from the justice about whether the use of the classifications themselves is somehow impermissibly unconstitutional, unless they sort of jump that maximum hurdle, there's not going to be any impact immediately on affirmative action, whether that's regulatory or voluntary. None. Why is that? Well, again, unlike what Sarah was talking about with respect to the special sauce, you're not supposed to be using the sauce, right? In Title VII. You're not supposed to be using that sauce in Executive Order 11246. You're not allowed to use race as any factor whatsoever. So the idea that the affirmative action, that's sort of Grutter-style affirmative action for education, if somehow goes away, that it's going to sort of impact employment, it will have no impact on employment because you're already there. Likewise, the thing I will say about that is the lessons from employment that we're already doing on the ground can help schools and universities to sort of figure out how to do this because everybody else already is doing this. But there's no doubt that depending on the dicta, depending on some of the stray language and the decisions, it's going to have some trickle-down effects. It could build momentum for more attacks based off of diverse programming and other sort of reverse discrimination claims. There could be having a chilling effect on DE&I generally. And frankly, just, I think the big concern, you saw this in the amicus briefs, is that, look, corporate America, the military, other external entities, they depend on colleges and universities for their sources of professional and other employees. And if they're not a diverse representative body to recruit from, then what's that say about the ultimate impact on corporate America? And so I think that's a huge concern for most employers. And, we'll just have to see how this plays out. But Sarah, anything in particular you want to say about Texas A&M? Because I know you were watching that case pretty carefully.
I do. And even though this is a case arising in the university context, it's really important for those at corporations to be aware of this as well. So a class action or purported class action lawsuit was recently filed against Texas A&M under Title VI, Title IX, Section 1981, and the Equal Protection Clause. And the argument that the plaintiffs are making in the case is that Texas A&M, along with, quote, nearly every university in the United States, gives preferences to female or non-Asian candidates for faculty positions at the expense of white and Asian men. And it cites to a faculty hiring program at Texas A&M that I know so many institutions have similar programs that stem from DE&I initiatives that provides funding for faculty from underrepresented groups and provides additional or special faculty lines for those not in the higher ed space, a faculty line is basically like an employment vacancy. So it criticizes Texas A&M's program that provides special faculty lines for underrepresented groups. And the lawsuit itself really takes aim at DE&I broadly. And so to Brian's point on his slide here, I think depending on what happens in the Harvard and UNC cases, it will open a door that I think is already getting pushed open for people to jump in and say some of these DE&I initiatives are actually engaging in hiring practices on the basis of race, and you can't do that. If you want a copy of the Texas A&M complaint, please email me. I'm happy to send it to you. But I'm watching it very closely, and I think that we will get more cases like this soon.
Yeah, so thanks, Sarah. I definitely agree about that, and we're seeing this already. Even in the non-education space, this is a contentious time in America for all sorts of different reasons, and there's a lot more focus on these efforts, and there should be more focus on these efforts, both on the positive side and to make sure that they are working in the way that people intend. Related to that, in closing, let me just mention a couple different things. Well, Sarah's going to weigh in as well, but I think if you're thinking about, so what do we do now? We've got till next spring, next summer, before the final decision drops. Well, one thing you could be doing is evaluating your relative risk. And this is a slide from the employment setting, but it applies in education as well. There's no doubt that there are certain DE&I practices that courts have taken a look at before and have given a very clear thumbs up to. And there are other practices that are more on the edge or well over the edge. And trying to look at what you're doing with that lens on a relative risk scale and try to determine, frankly, how okay are you or not about being up at that edge. I think is an important exercise. And again, there's lots of case law that's already out there that helps benchmark where that risk is. Related to that, though, boy, if you're going to do that kind of analysis, Sarah and I would say and highly recommend that you do it on a privileged basis. Keep in mind, it's good to sort of do a self-assessment, but when you're doing that self-assessment, you are creating documentation about what you are doing pro and con, and you need to be honest about that evaluation. But doing that in a privileged setting, I think, can certainly help you do that. But related to it, there's no doubt that there are certain things that are more concerning than others. And, Sarah and I were talking about this before, but I think the number one item that we see especially in the employment setting, is diverse slate practices on interviews and selection. This got popular after the NFL, among others, adopted it as the Rooney Rule. And people look at that all the time and say, well, what's the problem with that? NFL does it. People talk about it all the time. Why should I be concerned? Well, unlike the NFL, most people have options for other places of employment if they turn around and sue the hand that sort of gave them that opportunity. And in fact, diverse slate requirements are very legally controversial, I will say, because you are taking race into consideration directly in selection. Even if it may not be the ultimate selection, you're definitely putting your thumb on the scale of the final interview slate. And that itself is a form of discrimination that OFCCP and others take a hard look at. So you've got to be really careful about that and take a look at it. And likewise, as Sarah mentioned this earlier, I think you ought to take a look at your language, your materials, what you're putting on your website, what you're putting in your brochures, to make sure that how you're stating your position about the good things that you're doing, the legal things that you're doing, don't imply that you're doing something different. Because in this day and age, especially with litigation, it'll come back to haunt you. But
and I think,
other
Brian,
things
I think your point about HR training is really important for our friends in the employment context. So when people hear about affirmative action from the regulatory lens, I think they interpret it to mean increasing under the presence of underrepresented groups. And I think what you and I know that's really important in the regulatory context is underrepresented, you really have to dive into the data, and you do it by job group, right? So hiring 3 African-American custodians in a job group where you're already overrepresented with African-American males, let's say, that's not going to help your overall affirmative action goals. You really need to be breaking it down by job groups and having a nuanced conversation about it. And so to me, folks at colleges and universities who are dealing with this on the employment side, folks in industry who are dealing with this, you need to bring together your DE&I person, your affirmative action person, and your compliance type person, your EEO person, to kind of all get on the same page, and the legal department, of course, to all get on the same page. How are we talking about this? How are we thinking about this? And how are we harmonizing? Because these things can all live in harmony, but you just have to have a shared understanding of the terminology, and you have to have the different people who work on these issues working together. So kind of, in closing, I think you need to be having these in-depth conversations with folks about what you're actually doing on the ground. For my college friends, college and university friends, are you periodically looking at race-neutral alternatives? Could you pass that Harvard-level strict scrutiny about your own practices right now? I was with a client the other day who said, we don't use quotas, and then they handed me a document that said 43% of our class needs to be from X group. And I was like, that's a quota, right? So I really having an understanding of what's out there, and then thinking very carefully about which other stakeholders at your institution you need to loop in. I would be looping in my development team to be thinking about the potential impact of a ruling in the SFFA cases on race-based scholarships and sex-based scholarships and race-based donations that you're receiving from your donors. And I highly recommend, and again, happy to talk with folks about this if needed, doing a training for your development folks on this area of the law, because they're a very important piece of the puzzle. So we've gone a couple minutes over, but I think, and I'm sorry we didn't get to the questions. We'll follow up with you all on those written questions that we received, because we did receive a few. But please reach out to us anytime. We would love to talk with you and kind of help you or your institution or your organization think through these challenges. And I want to thank the folks at McGuireWoods and our marketing department who helped set this up, and most importantly, my co-presenter, Brian, for sharing his expertise. So thanks so much, everyone.
Thanks, everybody. Have a good afternoon.
Bye-bye.